over to Lauren Swisher. She's going to be the moderator for tonight. Thank you. Thank you all for coming.
Thank you, Pam. Good evening, everybody. My name is Lorna Swisher. I have been asked to moderate this meeting on behalf of the trustees this evening. It is our township informational meeting on the topic of annexation, and the format will be, we'll have a presentation for about 20 minutes, 20 to 30 minutes, and then we will take questions after the presentation is complete. I know everybody has a lot of questions, but I will ask you to please keep your questions to maybe 2 per person so that lots of people have the opportunity to ask questions. Now, the number one thing on most people's minds is, are there any pending annexations right now that are before? And there are none, but there are a number of parcels of land in Bethel Township that are vulnerable to annexation. So we'll go ahead and get started with the presentation, and then we will turn it over to questions as soon as the presentation is done. So this evening we're joined by Simon Patry. He's a partner in the law firm of Dysinger Patrick LLC in Tip City. Simon serves clients in the greater Dayton area in business law, estate planning, real estate, and litigation. Simon graduated from the Ohio Northern University Claude Pettit College of Law, where he got his Juris Doctor, and Illinois State University for his Bachelor of Science. He's licensed to practice law in Illinois, Ohio, and the U.S. District Courts in Ohio's Southern District and Northern District. Simon, his wife, and 2 children live in Tip City, and he currently serves on several local boards, including the Tip City Board of Education, the United Way of Miami County, Ohio, and the Tip City Chamber of Commerce. Simon.
Thank you. Thanks for having me here tonight. I was asked to talk about the Ohio annexation law generally. I've got a PowerPoint presentation where I'm going to discuss the various types of petitions and some of the more meaningful provisions of the law as far as what the conditions are and when they're approved and when they're not, and the limited amount of power that the county commissioners and township trustees have related to them. I had put this slide at the end. I think it might be useful for me to talk about it now. Just real quick, the history of annexation law, it's essentially started in the 60s. It's always favored urban growth and extension of municipal services, especially to rural areas. And because of that, the legislature, when they passed the laws, they made it very, very difficult to challenge them. The last meaningful revision to the law occurred in March of 2002. This was their alleged attempt to better balance the issues that are near and dear to your hearts versus the urban growth and development. Mainly from the township trustee standpoint, a township is maintaining the character and feel of your community, as well as the loss of property tax dollars, which may or may not be realized or different extents depending on circumstances. But at the end of the day, the law didn't do too much to change the ability to challenge the annexations, just kind of change the various types of procedural and technical requirements related to it. So the role of township trustees and county commissioners are still very largely limited. So there's really 5 ways you can do annexation, and this is what we're going to talk about, as well as kind of the nuts and bolts related to those. There's something called an expedited type 1, expedited type 2, expedited type 3, annexations that are municipality initiated, and then the regular or the majority, and that's essentially when you've got a group of property owners with 51% or more, but less than 100%. So the overview of expedited type 1 is it requires signatures of all property owners in the territory. And that's kind of important, meaning that if you're not in the territory where they're going to be annexed, you don't really have much of a right as far as objecting to, or your signature really, or lack thereof, makes no difference. So if you've got 100% of all property owners in the territory to be annexed, signing on to it, then there's no hearing required. And on an expedited type 1, Practically speaking, then, you just need the consent of the municipality where it's being annexed and the township if the township joins. So expedited type 1, the township joins in the form of an annexation agreement or a cooperative economic development agreement. Now, that's done primarily to assist the township to continue developing and capturing economic growth and opportunities. And then expedited type 2 kind of deals similarly when the township may not join. So again, all property owners in territory, no hearing, or type 2, no hearing required, but in this instance, you may or may not have the consent of the municipality or the township. And then further, the territory annex is not at any time at that point to be excluded from the township and remains subject to the township's real property taxes. However, though, there's always exceptions to the law, and this is no different. In instances where the township and the municipality come to an agreement, then it could also potentially be removed. Expedited type 3, this is an economic development tool. It again requires all property owners of the territory to be annexed to sign. The purpose, though, for it has to be to undertake a significant economic development project. Now, again, that's not going to be excluded from the township unless the parties agree through an annexation agreement or a CETA. It has to meet certain threshold requirements, and whether there's a hearing on it with the county commissioners depends on the consents and lack thereof. Then there's the annexation by a municipality for either municipal-owned land, county-owned land, or state-owned land. This applies to contiguous land only when it's owned by the city, the county, or the state. And its annexed territory remains part of the township. It can't be excluded, but there's no hearing required. Regular annexation, this is where perhaps there's a little bit more discretion as far as quote-unquote challenging it. This is when a petition is signed by 51% or more of the property owners, but less than 100%. This does require a hearing, but it does not require that the territory annex remain with the township of origin. But if it is removed, then the law requires that the municipality will compensate the township for its lost revenue, and there's a scale that, depending on the circumstances, that applies in the statute. So a closer look. We've talked about what expedited 1. Everybody's joining, there's no hearing required, but you gotta have consent from the municipal corporation as well as the township. No hearing, there's no notices provided, and if it meets the technical requirements, the county commissioners have to approve the annexation at their next regular meeting. There's no appeal available. All the owners of the land that joined the petition waive their right to appeal, whether at law or by equity. Type 2, this again requires that all property owners of the territory to be annexed join. There's no hearing required, but a review is conducted by the county commissioners. It may or may not be joined or consented upon by the municipality or township. It should be noted that the consent, quote unquote, is really whether we, as a township, object to the expedited type 2 petition, and then really you're only limited to objecting to whether it meets the technical requirements. Further, in this instance, the territory is not annexed at the time unless, and it's then therefore it's the subject, let me replace that. It's not excluded from the township and remains subject to the township's real property taxes. Again, though, unless people agree through an annexation agreement or cooperative economic development agreement. By people, I mean the township and the municipality. Under this one, there's notices to the political subdivisions and certain property owners, the ones that are part of it, and then around it. Under this procedure, the problem of land related to incompatible property adjacent to the area is addressed. So what we're really talking about here is the buffer zones. But that means that these areas were subject to zoning at the time the petition was filed. The townships and municipality can again may consent or object to the proposed annexation. But again, that objection is only on the basis that one or more of the statutory conditions aren't met, not that they don't want it to occur or reasons that go beyond the statutory conditions. If no action is taken, then it's deemed to be consented and the annexation goes through. If both the township and the municipality consent to the annexation, the commissioners must adopt a resolution granting the petition at their next regular session. If they object, then there's some procedure that occurs, which is really largely a review. It's not a hearing. The commissioners have to grant the petition if these statutory conditions are met. First, there's technical requirements that are satisfied. The petition was properly filed. The persons who signed the petition are owners of the property in the area proposed to be annexed. The petition contains the signatures of all property owners in the area proposed to be annexed. The area proposed to be annexed does not exceed 500 acres. The territory proposed to be annexed shares a common boundary with the municipality for a continuous length of at least 5% of the perimeter of the territory proposed to be annexed. The annexation will not create an unincorporated area of the townships that is completely surrounded by the area proposed to be annexed. And the municipality has agreed to provide the area that's going to be annexed with services specified in the municipal services statement. If a street or a highway is going to be divided by a boundary between the municipality and the township to create a problem, it's not necessarily a reason to object so long as the municipality has agreed as a condition to the annexation to assume the maintenance and responsibility related to that road or to somehow otherwise correct this issue. On an expedited 2 annexation, there are no rights to appeal. However, any party can seek a writ of mandamus, just extraordinary relief sought by the court, to essentially order the Board of County Commissioners to perform the duties under the procedure. Expedited type 3, this again has to be joined by all property owners in the territory. The purpose has to be for a significant economic development project. And the territory annexes not to be excluded from the township and remains part of the township's real property taxes unless there's an agreement or an annexation agreement or a cooperative economic development agreement that's been entered into. It does have certain thresholds, and the hearing depends on whether the municipality and the township consent. So the thresholds are, you have to show that there's a significant economic development that will result. That's defined by the law, and the law states that this means one or more economic development projects that can be classified as either industrial, distribution, high technology, research and development, or commercial. The projects can include, though, some ancillary residential and retail uses. From a money standpoint, it requires that there's a total real and personal property investment of more than $10 million and new annual payroll of at least $1 million to qualify as significant economic development. Additionally, the project has to be certified by the State Director of Development as meeting these requirements. Additionally, there's notices to political subdivisions. Certain property owners are also sent notice. This is accomplished by the agent petitioners. The townships and municipality may consent or object, but again, that objection is only related to statutory conditions. If both the townships and municipality consent to the annexation, the commissioners must adopt a resolution granting the petition at their next regular session. If either the township or the municipality object to the annexation, the commissioners must hear the petition at their next regular session, and notice of the hearing must be given to the parties by the agent. The petitioners' parties are defined by the statute. At the hearing, the parties can present evidence, call witnesses, cross-examine witnesses, etc. And then within 30 days after the hearing, the board must either grant or deny the petition based on, again, the conditions, which are, did you meet the technical requirements? Was it properly filed? Did everybody who owns property in the proposed area sign the petition? It has all their signatures. There's no highway that's going to be divided or segmented by boundary lines, or it's going to be dealt with by the municipality as part of the condition. Municipalities adopted a statement saying what services are going to be provided and the approximate date that those will begin. And then finally, again, the director and the Department of Development has certified this for significant economic development thresholds. There's a limited right to appeal. If the commissioners grant the annexation, there's really no appeal. And then if the board denies denies a petition, only an owner who signed a petition can appeal. Annexation by a municipality from municipal, county, or state-owned land. This is when a municipal corporation wants to annex land that it owns or that's owned by a county or state, the state of Ohio. Its annexed territory remains part of the township and does not get excluded. In order for this to happen is that the petition has to indicate the territory annexation was authorized by an ordinance passed by the municipal legislative authority, essentially that the city's passed an ordinance, they're going to do it. And the territory has to be contiguous to the municipality and is entirely, so it has, if you've got some owners wanting to join, that doesn't work. It has to be completely owned by the municipality, the county, or the state. If the land is state-owned, you need written consent from the Director of Administrative Services, and then that occurs and resolution of the Board of Commissioners approving annexation is adopted. There's some limited powers to deny the petition, essentially from really our practical purposes. It's when the commissioners can deny it if it's county-owned land. And again, as most of this is, there's no appeal for this type of annexation. There's certain things that aren't allowed. The straw man annexations are prohibited. Essentially, this is where the city would purchase the property below what the fair market value is and sell it or agree to sell the property back to the person it bought it from. If that occurs, then it's going to be deemed void and then the property goes back to the township. So then the last annexation we're going to talk about is the regular annexation or the majority annexation. This is the annexation that occurs when you've got a petition that's signed by 51% or more of the property owners, but not 100%. This does not require that the territory annexed remains with the township of origin. But again, if it's removed, then the municipality has to compensate the township for its lost revenue. That's not perpetuity, it's based on scale. Regular annexation conditions and considerations. Again, the persons who sign a petition are the owners of the real estate. There's a number of valid signatures constitute the majority of the owners of that portion that's going to be annexed. And then the municipality has to comply with the requirement to adopt an ordinance related to the services they're going to provide and when they're going to start providing. The more subjective criteria is really based on two things, and it's not really clear what that means because the case law is still developing. And there's some things that contradict them, the case law does contradict itself. But the two things that really would be something that someone could argue about is that the territory is unreasonably large. It cannot be unreasonably large. There's no objective criteria as far as acreage on that point. And then the next one, on balance, the general good of the territory proposed to be annexed will be served. And the benefits of the territory proposed to be annexed in the surrounding area will outweigh the detriments to the territory proposed to be annexed in the surrounding area. And you can tell a lawyer wrote that. There's no way to say it otherwise. Again, it's hard to discern, so what I thought I might do is I looked up some cases and put them in here to kind of give you examples of what the courts have done with this. So the other thing, and I'll talk about that after this, is that in this type of annexation, they look at the surrounding area, and that means the territory within the unincorporated area of a township that's 1/2 mile or less from the territory proposed to be annexed. Again, no street or highway can be segmented, and unless they're going to take care of it as part of the condition for the annexation. So illustrations. So in this instance, there's a case called Tiscaros, somebody else pronounce that, help me out. Township, thank you, versus Stark County. In that case, the Board of County Commissioners determined that the annexation would not serve the general good of the territory. When it got appealed, the Court of Appeals said, we feel that your determination was not supported, and that because the area would receive additional beneficial services, that they felt that was enough. Another one is Plain Township. In that instance, they found that the general good requirement for annexation was met because the annexed property would benefit by receiving city services and the surrounding area would benefit from a general cleanup of some of the portions of the property that had some debris and waste. And so you can see there's not a lot of things that need to happen for somebody to determine, at least in the Court of Appeals, that this is sufficient. Another one is that they felt that the evidence showed they benefit from water and sewer privileges, as well as professional fire and police services, building, zoning, and health departments. And on this one, the County Board of Commissioners' determination that an annexation request was for the general good of the territory was supported by reliable, credible evidence because the only negative was the difference in tax percentages compared to the many positives gained from the services provided to the portion being annexed. So then when we talk about the it can't be unreasonably large territory, there's some conflicting evidence, and the trend is not going in favor of finding against annexation. The first case was found to be, county commissioners had the right to deny the annexation because the evidence that the emergency services issues would arise because the way the territory was done, it was zigzagging everywhere, and that was going to cause some issues with that, and additionally, there's going to be flooding and erosion in the township, supporting the board and the county commissioners finding that shouldn't occur. That was in 2003. In 2008, they kind of had similar facts, and in this instance, they said, well, yeah, but that's still not enough. And then they provided that, the services, and then the fact that the road maintenance and those items would be addressed by the municipality would be enough to overcome those issues. So, as you can see, there's very little that anybody can really do to stop these from happening. On detachment from municipality, there's really two ways for our purposes that really would apply. I've only really talked about one, and based on the annexations that have occurred in the past, my understanding at least, is that upon a petition from the municipality by majority to detach from municipality by majority of the freehold electors that own land, and that's the type of ownership you have. But for that to happen, the municipality has to assent for the detachment, and it has to do it in an ordinance that it passed for that purpose. And so you can imagine how many municipal corporations are going to say, yeah, we'll let that go. The other ones apply to agricultural land, and that's not in this slide, that's not in the scope of this presentation. Again, we talked about the history of the role of township trustees. And then what I did is I know that people like to look things up, which is, I think, a very good thing. So there's other resources that you can look at. Obviously, the law, which is the Ohio Revised Code. There's something called Law Writer. If you just Google a statute, it'll probably be one of the first things that pops up. But the relevant statutory provisions here you're looking at are 709.01 all the way through 709.50. Additionally, there's some resources available at Ohio Township Association website or the County Commissioners Association Ohio website. I think the county commissioners have some of the better ones because they're the ones that have to primarily deal with these issues, and they put some good stuff out there. Those resources aren't legal advice, and these are kind of convoluted issues. I only hit the highlights. There's a bunch of technical requirements, and it's procedurally and factually somewhat intensive to give somebody a real true answer. So the warning here is that this is just a summary of some of the aspects. It's not legal advice. And so if anybody has really more specific questions pertaining to an issue that they have, glad to talk about it, but it's not obviously this presentation. If somebody has a question about the general aspects and requirements, I'm glad to answer those. I'm glad to also talk about technical and procedural requirements if you have questions.
Thank you very much, Simon. Okay, I'm an old woman. Yeah, so thank you. If you have a question, please raise your hand, and I will bring the microphone to you. When you are asking your question, please put the microphone up to your mouth so that it's easy for all of us to hear over the PA system. So, right up front, first question.
I was recently informed by one of the city council members for the city of Cleveland Heights that any properties that are to be let's say that a property that's not currently in Carriage Trail to Parktown, but north, right up in, on 40 or on the other side of 202, those would be developed, that they would consume those as well based on what was written in the TIP agreement, which would allow that to occur.
I'm not familiar with the agreement, so that would be a question for someone else.
I don't think that we can answer that. I mean, we didn't sign that TIF agreement. That's not part of what the township did with Cube City Cube Heights. I'm pretty sure the TIF agreement is between the school board and the city council. You'd have to check that out, you know.
And as a reminder, please, when you ask your question, if you can state your name and your address, that just helps us to be able to document that who's here and to make sure that everybody that's speaking is a township resident. Thank you, Jacob.
Next question.
Hi, my name is Jasmine. I live.
Oh, did it die?
There?
Yeah.
You go get another.
And my question is, how much land can actually be annexed for yours?
So the question was, how much land can Huber Heights absorb before it takes all of Bethel Township? Is this essentially the question?
I think there's roughly 20,000 or more acres for Bethel Township. I guess I'd be pretty shocked if that would occur in my lifetime. For Huber Heights to annex land, they have the 5 ways that we just discussed. So for them to annex all of Bethel, they would have to satisfy one of those various petitions. And I guess the question is how long that would occur, or if it would occur. I don't know. I cannot foresee any facts that would support that would occur in anybody's lifetime in this room.
Because my issue is I live in Fulton, which is right on the border of Carriage Trail, on the part of the annex. And I'm just afraid that they're going to absorb it enough where we're now Huber Heights residents, and I have zero interest in being a Huber Heights resident again after you do it.
So I think your statement was that you live in Fulton. Did I pronounce that right? And that you have little to no desire to become part of Huber Heights, and your concern is that your proximity to Huber could result in you being annexed. And I think that the general answer I can provide is not knowing where you live or anything other than how many parcels of property in between, et cetera, or what the plans of the city are. Is that if you live close to Huber Heights and they begin to annex, or property owners are annexing themselves into the corporation, there's very little you can do other than what we've talked about in the presentation. So most of this is very objective criteria as far as whether you'd be annexed into it. Where the way that you would probably become annexed into it is if there was a quote-unquote regular annexation and your parcel was part of the territory to be annexed. That would require 51% or more, and then satisfying all the other technical requirements as well as the more subjective part of the criteria. Based on my feel of the room here, I think I'd be surprised if we had that many people wanting to go. If your land abuts a big piece of land, or like farm property, there's a few, or undeveloped property, and you have some developers that go there and buy the land, then you may have another issue. But without understanding the facts or more specifically, I can't provide a better answer.
So I don't even know exactly where you are in Fulton, but okay. So we all know, we can all drive along 40 and see the big water tower there, and we also all know that you don't build a new water tower at the edge of your community. You build it within the center of what you want your community to be. So they do have plans to annex north. They really do. And that's what we're going to talk about. How does that happen? And what does the township, how can the township fight? We do not, as Simon mentioned, have a lot of tools. And what that time frame looks like, we obviously, all of us hope never, but we also know that you can look at the map that isn't, most of you picked up, all those big empty parcels that are not shaded, those could be developed either, and they will, eventually they will be developed, either by Huber Heights or hopefully they'll remain in the township and we can do some type of development that's not Huber Heights, but it provides like a buffer zone, so that the property, and then it also creates a border, so we don't get future annexations north of 40. But they are 240, you can see that clearly on the map, and it's a worry, it's a huge worry for all of the trustees, and I know for a lot of residents in the community. So I unfortunately don't wish I had the crystal ball, but they're the responsibility.
So the question is, her question is, they were forced to come onto the Miami County water system so that Huber Heights would not annex them.
The reason for us here in the township, this has started quite a few years ago with the first 3.8 mill levy that was put in to help with infrastructure in the township, to be able to supply that infrastructure to developers so we can have control over the property and not the city of Huber Heights. And that's the reason why we try to do that along the southern border of the township. Is, it's like drawing a line in the sand. Somewhere you've got to try to draw a line in the sand. Will that stop that? I can't say yes and I can't say no, because it's up to the property owners that own the property, as well as most likely the developer that buys the property. And will they want to work with Bethel Township and our zoning, or do they want to just work with Huber Heights and what Huber Heights will offer them and let them do? So we have to, I don't want this place, I don't want Bethel Township to look like Huber Heights. I've been here a long time. I don't want that to happen. But we have to make some concessions to be able to make it more attractive to the developers to keep it in our township and let them work with us and work with our infrastructure versus working with the city of Huber Heights. Because once it becomes annexed, it's no longer Bethel Township. There's some confusion. People think that the people that live in Carriage Trails still pay to our fire levy or our township levies, but that's not so. That is the city of Huber Heights. They do pay school taxes because it's still part of the local school district. And I guess, does that answer your question?
Are you guys willing to do anything to make developers want to build in Bethel?
I mean, we can only do so much. We can only talk to them if they want to talk to us. We have met before with the current developer that is in Huber Heights, just to, to offer up, this is what we have. Whether they have interest in that, I can't say yes or no. It's one of those things, sometimes, it's who you've been working with makes you happy, so you stick with them. I hope that's not the case. I hope they will work with us, but I can't guarantee anything.
My name's Carolyn Murray, and I'm one of the newest trustees. I am the newest trustee. I'm just going to stand up and yell. And I've lived in Bethel Township most of my life, and I've been a trustee less than 2 years. And when I came on, I didn't realize annexation was even an issue anymore, because I remember like 15, 20 years ago when we were all anti-annexation, and I thought that was all done and past. So to answer your question, I had to learn a lot, and it's terrifying. Because as Simon said, townships don't have very many options when it comes to stopping annexation. When we were preparing for this meeting, one of the things that came up is the law is written in favor of municipalities. The law is written to favor development. That is who writes the laws. That is done at the state level. Townships we're the lowest on the pecking order. We have very few options. The best option we have is to develop land, because once it's developed, we're not competing with Huber Heights to offer better services. As you heard Simon say, one of the things that citizens can do is say, well, we can get better water, sewer, trash through Huber, so we want to go there instead of staying in Bethel Township and having to put in a septic system and build a well, dig a well, and pay for our own trash. So one of the reasons the sewer and the water was so important is that gives us something to say we have this option. Please, developer, consider developing with the township instead of going directly to Huber Heights. And that's one of the struggles that we've had when we talk about development, is I don't think any of us want to see Huber Heights. It makes me sick to drive down 40 and see the farms that I grew up looking at now full of houses. And I think anybody that took the time to show up here tonight would agree with me. We all remember the way it used to be, but the reality is we cannot continue to keep it the way it was. We have to figure out a way to manage the development. And that's why having you all here tonight is so important, because I think a lot of us thought it wasn't a problem anymore. But if you've been in the school and you've seen the kids that are coming in and you've seen the houses just continue to grow, you understand that this is a real problem. And it's a problem that we don't have a lot of control to stop. So that's a really long answer. But I will tell you, and it's one of the things I've said over and over and over, every time we have these conversations, my mouth drops open, my eyes just I'm like, what? So when I see these things, and I will tell you that property across the street from Parish Trails, how many acres is that? The one across the street, on the east side of 201, if you pulled out at Parish Trails and went straight, 160 acres. Guess what's going in there? That's if I were a Parish Trails developer, it's easy to go right across the street, right? I'm not saying that's happening. We don't know that that is, but that's what I think when I come into Bethel Township. Is that the next parcel? When I'm driving down 40 and I see that nice open field, is that the next parcel? I don't know. What I do know is one of the only tools we have to stop Huber from sucking up our property is to develop it ourselves. And that's a hard thing for a lot of us to have to swallow. But that is the reality. And I can't be any more blunt, and I can't be any more plain spoken about it. And I'm telling you that because I'm brand new on the learning curve, and I lay awake at night and I think about this.
What do we as residents have to do to promote development?
We need to have conversations like this. This is the beginning. We need to have conversations. And there's a gentleman behind you, raise your hand, so I'm going to pass that back to you.
I apologize, I'm not a resident, but I'm the Director of Development for Wayne County. And Bethel Township has the only enterprise zone in the county, an enterprise zone that borders Huber Heights. So when you want to talk about development, at least we can begin there, have a conversation with the County Department of Development. An enterprise zone is a means to encourage development by providing some level of tax relief, but it also has the ability to put in infrastructure to help provide funding for infrastructure and things like that. So there are tools that a township can use in partnership with the county to do your own development. And that sounds like a theme that's recurring here, and so I would encourage anyone in here to reach out to the county.
Great, thank you. Bill?
My name's Steve Blaze. I live on Tree Road, so, I mean, in the conceptual barricade, if you will, or line in the sand, if the north side of 40 was developed by the township,
The south side.
well, the south side already eaten up with Huber. I mean, according to the map, if I'm looking at that, all that, everything is already Huber Heights.
Our goal is the water and sewer lines run along 40, pretty much the length of the town, not quite, but pretty much. Our goal would be to have denser development south of 40 and not north of 40. What a developer wants and what Huber Heights wants is the open land, and they can do what they want with it, so they have control of the development rights. And our hope is to create a buffer along the southern end of 40 so that we can work with the developer and have not a Huber Heights, but it's also not a Bethel Township 7 to 12 acres lots in that area. It's not going to fly because it's too risky. It's smack dab next to Huber Heights. They'll annex it in a heartbeat. And they can get more money. And at the end of the day, that's what it is to the developer, is who's going to give them the best bang for the buck.
Okay, but they have to annex land that attaches to their city already. So according to this map, this blue and black area is already up on the border.
Exactly, yeah.
Okay, so this is just a conceptual thing.
Okay.
I know you want to stay on the south side, but
We want to save it all, but
if you, it's draw a line in the sand. If you did just properties along the north side of 40, then got down around 201, and went down, did something to keep carriage trays from jumping across 201.
Right.
You know what I mean? Then they can't cross that line. They can't just jump over you and annex some more
Right.
without a hell of a lot of effort.
Right.
So, because the way it is now, somebody come in there and buy the land and just say, hey, we're going to Huber, we're all stuck.
Right.
So I guess,
And that can be a property owner's decision. That's not our decision.
Right.
If I own that 160 acres and I can sell it for $8,000 an acre for farmland, or I can sell it to a developer for $17,000 an acre, and that's the difference between leaving my kids $1 million versus $20 million. And my math's bad, so please don't use my figures. Just throwing stuff out there, right? But if I can make $1 million or I can make $20 million, what do you think I'm going to do? I'm going to go with the $20 million offer. And that's what we're up against. Landowners want to make, and I don't blame them. They've worked the land, they've owned the land, it may have been in their property. This is their family's land. And it's their right to do what they want to do with that. And that's where we run up against issues where we want to make it more attractive to a developer to work with us if we can in the southern end. We're not trying to, build up Rudy Road or 571 or any of those, but south of 40, we want to make it appealing or approachable at least to talk about development so that property owners feel like they can sell it to developers who are going to keep it in the township instead of automatically going to Huber Heights and say, just take us. Does that make sense?
yes, you really have to preach the choir and keep that in, keep it down.
And that's why these conversations are so important, is a lot of people think that the trustees have the power to do this, but it's property owners and the developers they're partnering with that make the decision about annexation. It's not a trustee issue as Simon talked about.
I don't mind, but I just want to. Anyway, I live south of 40, just right there on the corner, and I see the vision that when we work with countries, we don't wait for them to come to us. We have to go and stop them from invading and coming further into our territory. So I can see where we need to stop south of 70. I don't like the front of all the change south of 40, rather, sorry. I don't like a lot of it, but I'm not a lifetime resident of Bethel, but Bethel is in my heart, and I want to keep it Bethel. So even though we have to do a little bit of change, I know there's room to develop right in my backyard.